name is Kim Daniels. I'm an attorney with the Thomas More Law Center, which is a national public interest law firm. I'm also a Maryland resident. I'm here today to talk about specific, serious legal problems with this bill. In their eagerness to achieve very worthy goals, the proponents of House Bill 1 have given Maryland's academic and biotech communities carte blanche to pursue highly controversial research, including therapeutic cloning, while providing neither effective oversight nor sustained consideration of the profound ethical concerns that arise in such research. Given the recent findings of substantial fraud by South Korean researchers, I believe that these concerns are particularly important for us to consider today. First, House Bill 1 institutionalizes conflicts of interest on the part of the biotech industry and the academic institutions in Maryland. On its face, HB 1 places great trust in the biotech researchers whose institutions, both academic and commercial, stand to gain from the grants and loans given from the Stem Cell Research Fund. Members of the peer review committee created by the bill are charged with making recommendations to the Commission for the award and disbursement of grants. Yet at least 6 members of the committee, a majority, will be directly selected by Johns Hopkins, the University System of Maryland, and the Maryland Bioscience Alliance, all institutions that stand to profit or whose affiliates stand to profit from the dispersal of grant monies. Now, a sponsor of this bill mentioned earlier today that there was a conflict of interest provision in the bill. In fact, again, as was pointed out, that provision simply refers to notice. You have to notify the committee that you are a part of these organizations, but you don't have to recuse yourself from voting on these grants. Now, while the Stem Cell Research Commission, the other oversight board in here, has a somewhat broader membership, its grant recommendations must be based solely on the rankings and ratings of the committee regarding the award of grants and loans. In other words, the committee has the real power to determine where grant monies flow. This creates a situation that's ripe for self-dealing. Already, California's stem cell initiative, on which HB 1 is modeled, faces litigation challenging it on similar grounds. We've heard a lot of talk about California today, and so I want to show you an article that I read this weekend in this Sunday's San Francisco Chronicle. The headline reads, "Stem Cell Effort Mired in Legal Blog, Global Scandal. With Proposition 71 funding on hold, California's lead role is in doubt." What it says in this is that no major grant monies have been dispersed in California, that they are at least 15 months away from dispersing any major grant funds in California, and that other states, such as New Jersey and Missouri, are proceeding with extraordinary caution given the problems that California has faced and given the recent situation in South Korea. Secondly, HB 1 relies extensively on institutional review boards, or IRBs, to protect against these conflicts of interest. Grant awards, for instance, are made contingent upon approval from an IRB. You heard Dr. Gerhardt earlier in discussing the South Korean situation. He said this won't happen here, and he pointed to IRBs as the protection against it happening here. But these do not provide real protection against these conflicts of interest. The Maryland Supreme Court has noted as much. And this is not me talking or any advocacy organization. This is the Maryland Supreme Court in the Grimes v. Kennedy case. IRBs are primarily in-house organs. In our view, they are not designed generally to be sufficiently objective in the sense that they are as sufficiently concerned with the ethicality of the experiments they review as they are with the success of the experiments. Vera Sharov, who's the director of a watchdog group called Citizens for Responsible Care and Research, says, "The trouble with the IRB system is that they represent the research center. Most of the members are employees of the research center. Too often the system is a rubber stamp and a sham." Finally, HB 1 does not provide for adequate consideration of the ethical concerns here. It relies upon IRBs to make those ethical determinations, and we've already seen the problems with those. It provides no standards by which the IRB should govern the ethics, should decide which is going to be a legitimate proposal, a legitimate grant proposal or not. And finally, contrary to what prior testimony alluded to, cloning is allowed under this bill as currently written, and I can talk about that more in comments if you'd like. Thank you very much.
Delegate O'Donnell. Delegate Haynes.
Thank you very much, Mr. Chairman. My question is to Council that just made a few remarks. Yeah, you made a comment or a reference, if I didn't misunderstand you, as it relates to the Supreme Court. Did you mention Maryland Supreme Court?
It's the Maryland Supreme Court.
From the state of Maryland?
State of Maryland.
Are you referring to the Court of Appeals?
Maryland Supreme Court.
Well,
This is from a Maryland Supreme Court case.
okay. Can you provide me with the site?
Sure. Grimes v. Kennedy Krieger, 782 A. 2nd, 807, Maryland, 2001.
Okay. I'd like to get that
Great.
afterwards. Thank you.
Okay.
Delegate Frank?
Thank you, Mr. Chairman. My question is for Ms. Daniels. You mentioned the California experience and how many problems there have been with getting that program off the ground. In your reading of House Bill 1 and how it's currently written, do you see any parallels with the situation in California as far as just any number of factors, as far as the financing of it, the structure of the program, the awarding of research grants and all of that? Could you walk us through that a little bit?
The California lawsuit that's going on right now, there are lots of different claims in it, but the basic thrust of the lawsuit is that the Stem Cell Research Institute has too much independence from elected lawmakers. And as the years wear on, and as this continues to get more public attention in California, it seems like California's citizens are starting to think the same thing. You can see in HB 1 that both the committee and the commission are appointed, that there's a lot of deference to the scientists and industry representatives on the committee who will be making these grant determinations. The oversight simply isn't there in this bill, and it's clear that should this bill be enacted, Maryland will be inviting costly litigation for itself. I mean, this happened in California. Things in California have been greatly slowed down. Other states are now proceeding with caution, not just because of lawsuits, but because there are so many great developments in adult stem cells that are happening, because there are altered nuclear transfer opportunities where we might not even have to do embryonic stem cell research because we have another way of getting embryonic stem cells. There are so many great opportunities out there that a lot of states are slowing down, and I think that Maryland would do well to do the same.